Hey everyone, welcome back. I am Ollie Taylor from Wisdom and Wayfinder, and I am joined as always with my co-host Frank Majorana from JustWorks. Frank, how's it going today?
Going great, Ollie. Going great. Thank you. How are you?
Good, very good. All right, and we are excited to have back with us for a second time Fay Szakal from Greenbaum, Rose, Smith & Davis. Fay, welcome back.
Hi guys, thanks for having me back.
Of course. All right, so for those of you who are joining us for the first time, a few weeks ago, we sat down with Fay and had what I can only describe as one of the most practical legal conversations that I've had about business. We talked about entity structure, we talked about operating agreements, and what the default provisions of the law actually say, which, spoiler alert, not what most people think that they say. And it's, we also talked about why it's important to get the legal foundations correct from the very beginning, because it's going to save you a lot of headaches down the road and expensive problems, down the road. And honestly, we could have gone for another 2 hours or so, I would say. So we decided to have Fay back so we could kind of pick up where we left off and go deeper into some of the stuff that comes up as your business actually grows. And so today we're going to be talking a little bit more about some of the hiring and employment issues that come up. We're going to talk about some intellectual property questions, and then also what makes a business sellable at the end of the day. The types of things that might kill a deal before you even get started. Again, this is all about thinking about, 5, 10, maybe 15 years down the line. What are the things that you need to be doing today to make sure that your business is prepared for all those different stages that your business might enter? And so for anyone who may be just starting to bring people on, let's talk about what do most people get it wrong right out of the gate. If you wouldn't mind starting there, Fay.
Sure, and I just want to give the caveat that Ali was so great to give last time, that this is not legal advice, that every situation a business encounters is nuanced and specific to their business. So whatever I say today is, generic, broad sense legal information, but independent legal counsel should always be consulted for the specifics of your arrangement and situations that your business may be facing.
Yep, 100%.
Sure. So one of the questions that we talked about bringing up today was employment issues. And especially when a business is beginning to grow, they begin hiring or contracting out services. In New Jersey, there's a lot of nuance to who is an independent contractor versus who is an employee. And a lot of folks fall into a trap of, picking up an independent contractor for 10 hours of work, and the Department of Labor actually views those 10 hours as part-time employment based on the specifics of the arrangement you have with that person. Having an agreement in place, a written agreement, a written contract with the independent contractor is one thing that will go a long way in showing the Department of Labor that this is an independent contractor. But it's also the actual relationship, the actual transaction between the independent contractor and the quote-unquote employer that distinguishes an employment relationship from an independent contract relationship. And this is important because under the laws in New Jersey, employers owe employees certain things, and employers are required to deduct certain withholdings from employees that are not the same for independent contractors.
Fay, along those lines, because that's very interesting. When you look at that, you're right. There's a lot of kind of requirements to say whether you're 1099 or whether you're W-2. But can you write in a contract? I think one of the things is are you using the client's tools or material or whatever? Can that be written in a contract so that the person can still be a 1099, but just understanding that they're going to be utilizing tools or items from the company?
Sure. A lot of it is dependent less so much on using the tools and the equipment of the entity, but more about who is directing the work that's being done by the independent contractor. So, and what the independent contractor is actually doing, the service they're providing. If they're providing a service that's within the purview of what the business provides, whatever the contract says, it is very likely the Department of Labor is going to view that person as an employee and not an independent contractor, because all that person is doing is what your business normally does. So let me try to put this in a little bit of context. You're a business and you need an accountant. You're going to enter into an independent contract with an accounting firm to do your auditing, to do your end of year financials and whatever. Accounting is not what your business does. Your business sells widgets. We're not an accounting firm. We need an outside party to do our accounting work for us. That person is going to have access to our QuickBooks. They're going to have access to our financial data, our bank accounts, our records. We're going to give them all of those tools that they need, but they are performing their audit and their financial work in accordance with their industry, which is their trade, and it's not what our widget company does. That's a true independent contractor that's paid with a 1099 that the employer entity, the widget company, has no obligation to that person. But let's say you want to bring on a part-time gadget designer. Okay, we're a widget company, but now we want to get a gadget designer on board. And we're going to make it an independent contractor because I really don't want to delve into hiring a new employee and really committing too much into the gadget realm. And so the Department of Labor, notwithstanding an independent contract being in place with the gadget designer, because gadgets and widgets are closely related, the Department of Labor may look at that like, this really isn't too distinct. This person is using your tools. Yes, they're creating a different product, but they're using your tools to do it to serve your needs in your industry. And therefore, even though it's an independent contractor, we, the Department of Labor, under the law, say they're an employee, and now you owe back employment taxes, you may owe benefits payments, you may owe other withholdings, and be penalized.
So that kind of goes in a different direction. So can a client own the intellectual property that's produced by an independent contractor?
Yes. Yeah, you can absolutely. You can build that into the contract that whatever is produced at the direction of your agreement belongs to you as the entity. It's really the test for independent contractor versus employee is in New Jersey. It's three-pronged, meaning there's three different things that the Department of Labor looks at, and it's really the control element, the control and the direction. And of course, as a company, you're going to give your independent contractor an idea of what you want. That is some direction, but it's the day-to-day control. Are you controlling their hours? Are you controlling where they're performing the work? Are they able to work for other people while they're working for you? Is anything that they design retained by them? Does it all go to you? That's one factor. The other is, again, like I said, are they doing something that's outside the scope of what your business actually does? Like a professional, like, you're hiring an independent contractor to do legal services or accounting services or what have you. And then thirdly, is it an independent trade that this person is engaged in? If you are a company hiring an independent contractor to paint the inside of your office, that's an independent trade that has nothing to do with your company. The Department of Labor is likely going to accept that person is an outside trade. Yeah. All of these things, there's multiple factors that would take forever to get into, but there's multiple factors on how you prove, if you're ever audited by the Department of Labor, that how you can prove that an independent contractor is truly independent. But at the end of the day, this is one instance where just the fact that you have a contract that says independent contractor agreement does not necessarily mean that the state is going to accept that it was an independent contractor relationship.
Yeah, because that's like so I'm thinking back to when I had my my marketing agency. It's like if I hired an independent contractor to maybe offer more services or expand the services that I was providing or offering, it's different if it's something that I can do myself, and maybe it's just like video editing or something like that, or something in addition, or just additional like graphic design work. As opposed to they have a unique skill that I cannot do on my own, but I'm bringing them on to sort of expand the scope of services that I can provide. Well, they're an employee, not necessarily an independent contractor. Is that
right.
kind of what you're saying? Okay.
Right. Are you having meetings with them on a daily basis? Are they working out of your office? There's a lot of nuance to it and a lot of evaluation. And like I said, this is an instance where just the fact that a person says, I'm an independent contractor, does not mean that the Department of Labor is going to accept that.
Yeah. Yeah, I think that's very huge for people to understand, because I think they assume that the label is enough to create that distinction, and really it's about what the Department of Labor sees and understands.
And I just want to say for the record, it's not about making situations harder for employers, but New Jersey is a very employee protective state, and employees have a lot of rights under New Jersey law that the Department of Labor and other departments within the state don't want to allow employers to circumvent by creative contract drafting.
Yeah.
And that's why, just because I say it's a duck and you say it's a duck doesn't mean the Department of Labor can't be like, girl, that's a swan.
Yeah. But it has wings and a bill and, floats on water. So why can't I call it what I want to call it? Yeah.
That ugly duckling is actually a swan, my friend.
Yeah.
Fay, I think no, but does the length of a project or the project name, does that have any, if it's saying, hey, in the contract, we're working on this project for this client, for this number of hours, like, does that make a difference?
Sure. If it's a temporary project and you're bringing on an independent contractor to work on a project, that can be a distinguishing factor for sure, because it's a finite timeline, and that's one element that you would bring into the fold to say, this is, it could be outside of our business course, or it's an independent trade that this person is bringing onto this project that we just need for this one project. But if that independent contractor is coming on for project A that goes from January to April, and then you rehire them for project B from May to September, and then you rehire them for project C, it's very likely that the Department of Labor is going to flag that.
Makes sense.
And especially if it's exclusive too, if this person is just performing services for you during that time period.
That makes sense. And what about as far as the location? You mentioned before different states have different rules. Is it governed by the state that the company is in, or governed by the state that the contractor is in?
Well, the company is beholden to the law of the state that it's paying its employment taxes to. Yep. With employees in different states, it really just depends on, again, the tax recipient. Because at the end of the day, the Department of Labor in whatever state is going to audit. The Department of Tax might audit based on the Department of Labor findings, and it's really a state-specific analysis. But the company, where it is headquartered and where it's primarily doing business, should really be paying attention to the laws of that state. And if they choose to hire remote workers in other states, it would behoove them to take note of what the rules are for that state in particular with regard to independent contractors, especially if that person is paying their 1099 income tax in that state.
Well, that's great to know for any, like, there's a lot of independent contractors out there, right? And that want to stay independent contractor. They don't want to go W-2.
Absolutely.
But kind of understanding, the laws of the states of the companies that they're working in is important. So thank you.
It is important. It's just the due diligence side of it. And at the end of the day, knowledge, the trope, knowledge is power, right? If you know it's there and you go to an attorney and say, this is what the law says, I'm not sure if it's going to apply or not, I'm not sure how it's going to affect it, we can generally draft to cover the scenario where that law is suddenly invoked by somebody. and the Department of Labor doesn't audit everybody all the time, every single year. And there's people who I'm sure have been on 1099 contracts for years and years and years that really should be employment arrangements that just haven't been discovered. And that happens. Everything in business, in general, is kind of like, it's a risk assessment. You know, are we doing the right thing or not? If we get audited, what's the potential fallout? And, you know, how do we deal with that? And the state isn't always right either. I know of a situation where the state was trying to prove that this company's lawyer from a law firm the size of mine was actually an employee of this small, like, mom and pop company.
Yeah.
That makes no sense. But, you know, the employer had to provide, you know, the business card of the attorney. The attorney had to write a letter and say, like, you know, I have 85 clients. Like, I definitely don't work with this guy. And it takes time and energy to sort of disprove the allegation once it's out there.
Mm. Cool. Yeah. Well, this is. I'm sorry, go ahead.
No, go ahead, Ellie.
No, I was going to say, like, I just want to give like a little plug for Frank and what you do at Just Works, because I know that you have a portion of your services, especially for those who are looking for talent that might be offshore or out of state, out of the country. You have services that allow people to sort of bring those things under one umbrella and just manage all that a little more easily. And so I'm just, you know, just wanted to give that kind of.
Yeah, no, absolutely. Thanks for sharing it. Yeah, we have the international employee of record, so you don't have to set up shop overseas to hire somebody. And we also have the ability of really helping you with some of those sticky HR issues, right? When you're talking about how do I decipher if someone's independent or whether they should be W-2, like, let's talk through this. We have resources that can help you with kind of sorting some of that out. But absolutely, but appreciate that.
Yeah, of course. You know, again, this whole series is about giving people access to the information that they probably wish that they had when they started, aren't sure of where to get it or where to go or who to trust, you know, those voices. So we want to provide as much information as possible of, like, what's available, what's out there. What are some of the misconceptions that you might be, you know, kind of walking around with as you run your business that could really turn into an expensive problem later on if you don't address it right away? And so, I just wanted to give you that opportunity.
Yeah, appreciate that. So, Fay, question along the lines of kind of, I'm setting up shop and I don't want to kind of get myself in trouble. What are some other things outside of, let's say, kind of getting back on track, outside of kind of clarifying, or, you know, who's independent or who's W-2? What are some other things you see or business owners need to kind of get straight?
So I think that every business owner, whether you're dealing with independent contractors or part-time employees or full-time employees, seasonal employees, should consider confidentiality agreements, even if you don't have a full employment agreement and you're just having at-will employees. A employee manual that the people have to receive that includes a confidentiality policy with a sign-off page, and you collect the sign-off page and keep it in their personnel file. Confidentiality is important because it's not just about it's not just about, you know, if you're this crazy chem tech company or have IP that's out the wazoo. It's also just your general business information, your financial data, you know, how well your company did last year to this year. You know, people talk about their employers, people talk about work, and that can sometimes come around and bite a small business owner if information about how they did last year is suddenly, you know, out there in the public sphere and their reputation declines because of it. So the key thing that you can do is at the outset of your relationship with an employee or an IC is establish, I expect that you're not talking about my confidential information, my business's financial condition, who my clients are, what my deals are, what, you know, my trade secrets, whatever they might be. If you're in a franchise, there's probably, you know, language that your franchise agreement includes that you need to, transmit to your employees or your ICs, things along those natures. So confidentiality is definitely one of them for even at-will employees. You don't want your dirty laundry being aired out in the public realm. So that's definitely one that I would consider. An employee manual, I think Ali would speak to this, having those SOPs in place, having expectations set, letting everybody know where they stand so there's no questions. And that's just a baseline. You can deviate from it. Some people say, I don't want a policy because then I'm beholden to a policy. Well, it's your floor, it's not your ceiling. You can always amend it and change it as you go along for whatever works for you. But laying an expectation out there is a good starting point. It makes employees feel more comfortable that they know what's going on in the situation they're in.
Fay, does access to that information play a role on whether it's considered confidential? Like, there's so much available online now about companies, right? And like, what's a trade secret and what's actually what's actually confident? Like, how do they decide? Like, all right, this is confidential. You're calling this confidential, but this isn't. Like, this is available to everybody. That
right. So what we generally do is we draft the definition of confidential information broadly to capture everything, but then we define the exception. So an exception is, it's not confidential if it's public information. It's not confidential if you knew it before you signed this agreement. It's already in your head. It's not confidential. We also make exceptions if information is subpoenaed or required to be revealed pursuant to a court order. If you have to share an agreement because if you're an employee and you're going through a divorce and your employment contract is confidential, but now you're getting through a divorce and the other person's attorney is demanding it, you have to produce it. So, we always bake in exceptions. But if there's an allegation that you breached your duty of confidentiality and you're claiming an exception, you have to prove that.
Yep.
You can't just say to your boss, well, your last year's financials were public record. Oh yeah, where? You've got to prove it.
Okay, makes sense.
For sure. We definitely, we build in exceptions because we know that there's an exception to every rule. But as far as confidential information, we want to draft broadly to capture every possible situation where a person spreads business that really shouldn't be spread and it's detrimental to your company.
Makes sense.
Yeah.
Well, I think along those lines, we had talked about like intellectual property and like in the process of creating those different things. So what happens or what should a business owner think about, when their best employee leaves and then, maybe they're not taking the details and the data, but they definitely are taking the information and whatever skill sets that they've created or certain processes they might have developed in the course of working for you.
Sure.
To another company, or if they decide to start their own company, right?
So that's another kind of twofold thing. So first, within that employee manual or with your employees, you should also consider having a policy in place that's signed off on where the employee agrees that whatever work product they have on your time, on your dime, with your equipment, with your tools, with your fundamentals belongs to your company. So, if I'm looking at our widgets and I'm like, if I added this to that widget, it would be an even better widget. That doesn't belong to me. That belongs to you. That they'll argue that it belongs to them unless it's in writing somewhere that what they thought of on your time, on your dime with your equipment belongs to you. So that's one thing you should work, obviously depending on what industry you're in, it's not relevant everywhere, but the product that your employees come up with when they're on your time and dime belongs to the company. So that's one. And the other component is what we call restrictive covenants. Restrictive covenants is that broad language that captures non-competition and non-solicitation and non-contravention. Those are the three nons. These are three ways to protect your business if your key employees decide to leave. Now, key employees, typically you should have an employment agreement. If there's somebody who knows so much about your business, who is so critical to you that if they leave, there's a risk, there should be an agreement in place. And at the very least, you should consider what these restrictive covenants should be. Non-solicitation and non-contravention are critical.
Yeah.
Non-solicitation is this employee leaving, we're going to call him key employee. Key employee can't nudge the person next to them and say, hey, I'm leaving, come with me, let's start our own shop. Or after they leave, start calling his old colleagues and say, hey, I'm doing this now, come over to my team. That's non-solicitation. Non-contravention is interfering with your customer and vendor relationships and your client relationships. Non-solicitation also is drags business away, but that is captured in non-contravention as well, because contravention is getting involved in your relationships and trying to break them open in some capacity. So you basically oblige this exiting employee from the very beginning of your employment relationship that when they choose to leave, they can't take your employees, they can't take your clients, and they can't interfere with your current business relationship. Those are really critical, because at the end of the day, if they go next door and they open their own shop, that's what they're going to do. They're entitled to work. Courts generally look at non-competition provisions and say, well, was this guy unable to work because you put handcuffs on him? And they'll let a person work. But non-solicitation and non-contravention protect you in that case, where your key employee opens up a shop next door, because they can't steal your clients and they can't steal your employees and they can't interfere with your current business relationship. Easier to enforce than non-competition provisions. Non-competition provisions are where you restrict a person from entering into the same business elsewhere or being employed by someone in the same industry. Generally, those have to be time and space dependent. So 1 year, 10 miles, 2 years, 25 miles. They have to be reasonable, because our courts look at the right to work, and they say this individual could not work, could not support their lifestyle or their family because of this non-competition. Therefore, we're going to remove the non-competition. So they have to be reasonable in scope, duration, jurisdiction, and generally they require some sort of financial remuneration. So, for example, if I'm requiring you not to compete with me for a year, I might have to pay you a year's salary when you leave in severance to tide you over until you can work again. So non-competition is kind of falling by the wayside a little bit. It's been a lot in the news the past few years. The Federal Trade Commission had a lot of, there was the potential that they were going to completely go away for just employer-employee relationships. That hasn't entirely happened. They are still a powerful component in contracts, but I would emphasize more having the non-solicitation and the non-contravention solidly within your contract.
Yeah, that makes a lot of sense. And I've seen that in the past where, even when I worked for another marketing agency and then left to go start my own, I didn't solicit, didn't tell anybody that I was, going out. I just left. And then years later, I've had clients that I used to work with at that company follow up with me to then do some work. But it's like, I was always very careful. Like, I'm not coming after anybody. I'm not trying to compete with you or anything like that. Like,
and there's things to consider from both sides, because as an employer, I want to make sure that the non-solicitation includes certain things.
Yeah.
Like, if you know that I'm going after this big fish client, you can't go after that big fish client because you've left. So I want to cover future relationships that you knew about when you were leaving. I want to include past relationships going back in time several years. But if I'm the employee going out, I want to negotiate language that's more advantageous to me. And I want to make sure that if I send out a bulk mailing to my county, every business in my county, if I happen to touch somebody that's your client, I'm not violating the non-solicitation. I want to make sure I can be active on my LinkedIn. and that being active on my LinkedIn with my current connections is not a violation of the non-solicitation. That if somebody comes to me directly, that's not a violation of the non-solicitation. And I want to make sure that specific language is in there so that if a situation arises where there's a lawsuit because I've violated the non-solicitation, I can point to that language and say, no, I didn't violate it. This was a carve out. So both sides are looking for different things. And that's where you need an experienced attorney in there to draft proper language to protect you, whether you're on the employer side or the employee side.
Yeah. Well, that just generated another question in my head in terms of, so if a business owner is thinking about selling, moving on at some point, and or somebody's going to wants to come in and buy the business, and then that kind of sends a shockwave through the employees that are there, like, okay, well, maybe I don't want to work for this new person. Maybe I'm really attached to my current boss, or, you know, I'm thinking, you know, this might be the time that I want to go out and kind of do my own thing, see how it goes. You know, what do you do in that situation? How do you both protect the business, but also the I guess the value or the equity that somebody might get from purchasing it?
Yeah, so that's a very complex question with a lot of components. And I'm going to try to break out little bits and pieces of it and be as clear as possible.
Yep.
You got 2 minutes.
None of this is
you got 2 minutes.
Yeah, okay.
You got 2 minutes.
2 minutes. Here we go. Power hour. No, I'm like, no. So listen. Buyers of companies, they are buying your employees if they so choose to keep them on. They do not have to. But technically, you know, they buy your operating business. Your employee census is given to the buyer, and the buyer can choose to keep all of those employees on or not. And typically they want to, because they don't want any disruption in business, and they want to keep things going in the status quo. However, part of the due diligence that the buyer is going to do when you're selling your company is they're going to ask for any employment agreements that you have, any employee manual you have. They're going to ask for non-competition agreements, restrictive covenants, confidentiality agreements, all of that stuff pertaining to your employees. They're going to want to know every nuance of how your employees are treated, the perks that they get, the bonuses, all of that stuff, because they are assuming the risk of those employees leaving on day one. And if they are not bound to stay on by agreement, and there is no confidentiality agreement in place, there is no restrictive covenant in place, that's an even higher risk. And that's going to be factored into the purchase price. And sometimes there might be an indemnification escrow put aside from the purchase price in the case that a key employee leaves. It definitely affects the value. The more likely it is that your key employees can leave on day one and open up shop next door. A buyer looks at that and factors that into their analysis on the purchase. And that's why there's 2 phases to a purchase, really. Like, that's why you execute the LOI to get your fundamental agreement in place, but then the buyer does a lot of due diligence, and the seller is required. And please, anybody who's ever considering selling your business, you have to disclose. Once you go to sell, all of your business information is part of that process. And you can't play it close to the vest. You can't say, well, I'll tell them that on the day we close. No, it's part of the due diligence process. And it's part of my job when I'm a seller's attorney to coax all of the information out of my client to give to the buyer so that the buyer knows everything and is going in with eyes wide open and cannot claim that you withheld something that later on affects the business. If you have a key employee that you know is going to leave on day one because he's said to you, I will never work for anyone but you, you need to disclose that. If you know of a client who is very likely going to leave within the next 6 months and they're your biggest account, you need to disclose that. So business transition from seller to buyer is a high risk situation, but there's an assumption of risk component to it. And the employees are definitely a part of that. And the liability for their bonuses, for their benefits, the whether or not they're bound by confidentiality agreement, whether or not they're willing to execute a new employment agreement with the new owner, all of that is a factor that comes into play with the valuation and the prospect of the buyer closing on the sale, for sure. So,
I'm sorry. Go ahead.
Go ahead, Frank.
I'll say just a follow up on that because you kind of mentioned it. As far as having contracts with your clients, right? A lot of businesses or industries don't have contracts with their clients, but they do have reoccurring work and reoccurring revenues.
Yeah.
What effect does that have on the sale price of like if you have those contracts in place somehow? Does that increase the sale price? If you don't, does that decrease the sale price?
Well, again, it's all like assumption of risk and an analysis, because everything is different. So there are industries where there aren't contracts in place. You have your top 10 customers and nobody is bound to anybody, but your goodwill has kept that relationship going for 20 years or 30 years. And goodwill is actually a valued component of the sale price. So the fact that you've had clients of longevity, notwithstanding that there's no contract in place, is attractive to a buyer. What will happen during due diligence and closer in time to the closing date is sellers are typically requested to and required to engage in conversations with their key customers, introduce the new owner, and sort of like massage the transition to make sure that that customer is comfortable and confident in continuing. For those customers that are contracted, oftentimes there's provisions within those agreements called change in control provisions, which is that the customer is entitled to notice if the control of your business changes, whether that means you've sold all the stock or all the assets or even just majority ownership. They're entitled to notice. And oftentimes that's tied to a termination provision, meaning if they're not happy with the sale, they can cancel the contract. Again, it's incumbent upon the seller to facilitate the relationship continuing, to get a written consent from that customer in many cases, and a commitment from that customer that they will stay on and give the new owner a chance. Now, you can't oblige third parties to stay in business with the company that you just sold. Like, it's just, you don't do that. But that is the risk that the buyer is signing on for, and the seller is just obligated to fulfill these this transitional kind of facilitation and very close in time to the actual sale. Because if the sale falls through and now you've made your clients all leery that you're trying to sell your business, that's not good either. That last week before closing is typically a critical time for the seller to really help facilitate the transition for the employees as well as for the critical customers. Selling a business is it's so wild. I mean, it's like selling your child, and like, everything about your child. You know about the mole behind their ear and like the itch that they get on the bottom of their foot every night. And you have to remember to tell the buyer all of those things, and it's stressful and overwhelming. It's really important that if you set yourself up over time with proper agreements in place and documentation and SOPs, and you have goodwill with your employees and goodwill with your customers, it makes it so much easier to transition.
Yeah, it sounds like a lot of those things that would actually kill a deal just has to do with sort of not keeping track of those things along the way, really documenting them along the way, and sort of trying to scramble at the end to pull together, all this information, that it just makes everyone skittish in the end.
Yeah, it's so much easier these days to be organized in your record keeping because we have, computers and cloud-based systems, and we can generate contracts relatively quickly and digitally sign them and file them in somewhere on a computer. When you're selling companies that have been around for 40 years, 30, 40 years, that were formed in the 80s and 90s, let me tell you, like, the paperwork is oftentimes non-existent, or it's you know, faded typewriter paper with like the fringe on the edge from the fax machine. Like, it's crazy stuff.
It's like on a napkin that's been in the owner's like wallet for the last 30 years.
Yeah,
you know, their first agreement, you know.
And it's often handshakes too. Like, I promised my secretary in 1983 that when I sold, I would give her 10% of the profit. And now suddenly the buyer has to be concerned with that. And it was just a handshake deal, but the secretary remembers and I remember. And so, you know, we got to take care of it. It's much easier these days to be organized. And so I encourage all of my clients to keep their documentation in an organized place. You know, you don't need to keep duplicates. You don't need to go bananas with it, but have your signed documents all in one place. And if you're questioning whether something should be a formal contract or a written policy or not, consult, you know, your trusted advisors, your attorney, your accountant, business advisor. If it's an employment matter, you know, your HR folks. Use your external resources to give you guidance on what should be kept and what shouldn't, and what should be drafted and what shouldn't.
Oh, Fay, that was a lot more than 2 minutes, just so you know. So I was keeping.
I'm verbose. I can't help it. I talk too much. This is why I got out of the courtroom. Blowing through all my argument time.
That's good. No,
yeah, but it's nice. Look, I love selling businesses for people. I love helping people buy businesses. You really are learning so much about a business when you do that, from coming from either direction. And the documentation and the transparency when you're a seller is just so important. You know, playing things close to the vest, keeping things under wraps, that's not going to help you in the long run. And it's going to expose you to liability after the fact if there's issues that you weren't clear about from the beginning.
Fay, I do have one other thing that I was thinking about. This is kind of going back to when we're talking about kind of intellectual property. You know, AI is used more often now than ever before in businesses. So from a legal standpoint, could you kind of talk through the any ownership that a client would or a company would have to any marketing material or any type of product that's created through AI? And kind of the minefield that's kind of created.
I can point out the issues. I'm definitely not an expert in utilizing AI for, you know, like let's say marketing materials and things for your business, but I can point out the issues with it. So with AI, depending on what service you're using, what you're feeding into it, what you're asking them to push out, you know, if you're giving them images of yourself and your employees and they're generating, you know, headshots or boardroom images or something like that based on what you've said it, that's a different animal than if you ask, give me a marketing material with a boardroom shot and, you know, XYZ on the walls. That image that AI produces, you know, you should do your due diligence. Was it generated specifically for you? Was it pulled from materials from somewhere else? Is that a real boardroom somewhere with real people in it that AI has pulled from some other website, some other realm, or just somebody's, you know, Pinterest board that they decided it would look good for your marketing materials? The content of what AI puts in your materials, you're responsible for what you put out in the marketplace. So if AI is misrepresenting something that you do or using language that is going to get you in trouble with a non-compete or violating some legal provision, that's your responsibility to correct that language. It is ignorance of the law is never an excuse. And I think the new phrasing is going to be like, ignorance of AI is not an excuse. You can't go and say, well, my bad, but AI wrote that. Like, no, it's incumbent upon you to check what you have. If something is truly independently created, then you can probably assert IP rights over that thing. And I know folks who've had, you know, AI create logos or create like little branding things for special initiatives that their businesses are doing. And as long as they've done their due diligence and made sure that that was generated specifically for them without using other folks' proprietary stuff, then you can likely make a claim for some proprietary right over it. But I would just be leery with AI. You know,
Yeah.
Plagiarism has always been a thing, and AI is a ripe opportunity for for plagiarism, because again, AI is just pulling from trillions of data points and trying to put together something that you want to see based on what it knows about you. So take that with the warning.
And with that, you know, it's like you said, it's pulling from trillions of data points and sort of coming up with an average sort of muddled, you know, soup of all these different things. You know, for this conversation of, okay, how do you make your business more valuable? How do you make your business more attractive? Not just for selling, but maybe for attracting like really good talent. Why would you want to dilute the authenticity and the integrity of your business and your brand by just giving it over to AI? Like, those are the things that I think about a lot, like in terms of, yeah, I want to work for this company because they're doing work that is unique and spectacular and you know, mind blowing. But if they're just going to use AI and it's all just going to come into like this soupy, you know, milquetoast mess, you know, why would I want to work there? Why would I, as a customer or client, want to work for a type of company if they're just going to give me something that's going to be spit out by, you know, a computer somewhere, or an algorithm somewhere that anybody else can have access to?
And look, I mean, I don't want to completely put down AI because it does help so much with efficiency and with giving like basic starting points. But I think we focus too much on the intelligence part of AI and not on the artificial part of it. And we need to remember that what AI produces still needs to be vetted and assessed with the human mind to make sure that it is actually responsive to the task that you have asked it to perform, to make sure that it is not violating anything that it should or should not be doing, and to make sure that if you're going to claim any rights over it, that those rights can actually belong to you. I used AI to help me draft a PowerPoint for a class I was teaching. And, you know, I gave it my basic, like, this is what the presentation is going to be. I want 10 slides. Show me what you got. And it did. And it was beautiful. The PowerPoint itself was beautiful, better than anything I could ever put together, because I'm not, you know, I'm an elder millennial, and that stuff is not my skill point.
Hey, I'm an elder millennial too.
elder millennial. But all the content, while the content was generic, and not generic in a way that I could give it to the folks I was presenting to, because there was stuff that was also wrong or misleading or so generic that it was just pointless in being there. Repetitive. You know, AI wanted to give me 3 bullet points per slide, and if it only had enough content for 2 bullet points, the 3rd bullet point would be just different words of the 1st bullet point.
Yeah.
and that's not a good look for me, because this is work product that I'm putting out there. So it was my responsibility, which I take very, very seriously, to go through and make sure that it fit with the content I wanted to present, the law that I was presenting on, and that it was substantively accurate. The slides were beautiful, but it did take me, they were generated in 10 minutes, and it took me about 2 hours to edit content. But that saved me 2 hours of just the make it look pretty time.
Yep.
You know what I mean? So it's our job to make AI actually intelligent. So let's make artificial intelligence turn actually intelligent with the human mind.
Actual intelligence. I like that.
Actual
And that's 100%. Like, you know I went off on a little rant because, you know, listen, I use my AI as well. I have it but I've trained it to speak in my voice on documents that I've written before AI was a thing, before that all came out. So it spits out what's unique to me. But I think this goes back to kind of like the purpose of this whole series when we talk about, yes, you can go to AI to get a marketing plan. You can go to AI to get like an idea of what should be in some type of operating agreement or whatever. But the one thing that AI can't give you is the certainty or the experience to understand if what it's spitting out is actually correct. This is why you need to talk to professionals like yourself, Frank, Seamus, and Joe and Fleetwood, the other people that are in our group. It's important to have that because we've seen things, we've gone through things, we understand the little nuances that isn't going to come out from an amalgamation of trillions of data points, and that's why it's just important.
Well, here's a great example of something I was talking about with someone earlier today. Business insurance. Oftentimes folks think, well, for what I do, I really don't need a business insurance policy. And then I can point out various scenarios in which, hey, your home office, are you ever going to have people for your business come to your home? Oh, well, yeah. Your homeowner's insurance is not going to cover that if they're injured going to your business in your home. So you need a business policy. You can take a business insurance policy and feed it into AI and say, tell me what this covers and what this doesn't cover. And AI can probably spit out a list. It covers XYZ. It doesn't cover ABC. Terrific. However, people like me, I was an insurance defense attorney. And I represented insurance companies and was assigned cases to defend on their behalf. I also handled what's called their subrogation matters, where insurance companies try to get other insurance companies to pay on their policies. So I have experience. If there's something on that list that's not covered and you think it should be, or you're questioning why it isn't, I might have the experience to draw from. Or if I don't, I have an arsenal of attorneys and an arsenal of records and an arsenal of court cases that I can go through and say, this is how New Jersey courts interpret this, and this is how we can fix the problem. This is what we can ask your insurance company to do to make sure this event is covered. So yeah, AI is great for basics, but the AI needs to be turned into like actual intelligent work by a human person going through it with you.
I love that.
I'm gonna actually trademark it as soon as we get off this Zoom.
Yeah, definitely do that.
Yeah.
Although, does the trademark go into effect the moment that it's being that this is live, being recorded, the moment of
this is its first instance in use, and I can point to this, and since it's recorded, I can submit it to the USPTO.
Oh man, that'd be really cool. If this becomes part of your like trademark application, that'd be awesome.
Yeah. That's really fun. We do trademark here at the firm. So let me know if you trademark these. And that's also another thing to consider for selling a business. We very briefly, I'll just say, if you do have a logo that you're proud of, or a name that's clever, or something that you want to protect because you're scaling outside of your county, outside of your town, outside of your state, outside of your region, outside of your nation, trademark protection for your name. Some things are not trademarkable, and the attorneys at my firm can kind of coach you through how to protect that IP, which is also attractive in a business sell scenario.
Yeah, because that's like another asset that they can have.
It is, absolutely.
Yeah, it's awesome.
Yeah.
Cool.
Awesome. Well, we're at 53 minutes.
Yeah.
So I know we've gotten a little bit over than we usually do.
Hey, listen, I'm used to it with you folks. You're getting all this timeline. I talk too much. It's one of the reasons I was told as a little girl that I should be a lawyer. Like, you talk a lot.
And, no, but I know I can speak for Ali. We absolutely love to have these conversations because you bring so much knowledge, a great perspective, and you kind of break the stuff down in a really easy way.
Well, I love what I do. I love the experiences I've had in the various facets of law that I've practiced because I was a litigator. I've done municipal work. I've done a broad gamut of things. And being a business transaction attorney, I really get to draw on all of my prior law experience to help my clients in a vast array of scenarios. So I love what I do, and I love talking about it, and I'm happy to be here with you guys. You guys are great.
Okay.
Awesome.
Awesome. Well, I think at some point we're going to have you. Well, obviously we're going to have you back, but I think we want to have you back with Joe, just to have like a little bit of a volley to talk about. You know, again, there's two conversations that you should have: is your business transaction attorney, you know, setting up those organizing documents, then also, you know, being able to have your accountant or CPA involved in terms of the tax structure and, you know, really what are the things that you should be thinking about on that end. So
yeah, I mean, and that's a huge conversation for scaling for employee purposes. You know, at what point should you consider going the S Corp route, converting your business from an LLC to a C Corp, going from a general partnership, which does not require business registration, to an LLC. You know, these are all questions that are pertinent and tax-based as well as law-based.
Yeah, we didn't even get that deep into C Corp or anything with Joe, so we definitely got to have a follow up on that.
Yeah. Oceans of information out there. So.
Awesome.
Yeah, but this has been awesome. This has been really great. Thank you so much for making time to come back and join us. You know, it's just always really great information, and of course, just being able to have that time with you. So we appreciate it.
Thank you, guys. My pleasure.
Yeah.
Awesome. Thank you, Fay. Thank you, 𝗍𝗂𝗶𝗹𝘁.
Absolutely. All right. So next week we will be here with Mike Z from, I still have to practice his last name, 409, to talk a little bit about what he does. From my understanding is, you know, we talked about actual intelligence. He is someone who builds like dashboards and can take all the data points and information for business owners and really cultivate it in a way that it's easy to understand and see, so you can make those decisions much faster. But we'll dive into that next week when we next Wednesday at 11 a.m. Eastern Standard Time here on LinkedIn and other platforms. But till then, have a great week.
Thank you. Take care, guys.